May I please have Lordship? Judgment.
For delivery of judgment, item 45, WPC 4514/2017. Bimal Devnath versus the Union of India.
This repetition is dismissed. Otherwise. Yes. My lord, I have a prayer for upgradation of an item, my lord. Item 19, my lord. In this case, my lord, there are altogether, my lord, 9 petitioners, out of which, my lord, the reference was initiated against the only one petitioner, my lord. Therefore, this matter may kindly be taken up at 2 p.m., my lord. 19. 19, my lord. Okay, try to. Yes, my lord. Indicate.
Lord, item 5 for
5. Yes.
In this case, your lordship, on Monday, our bid has been paid for want of the bidder, but one private city is being involved with some.
No, but why it should be kept pending here? The issue is
with the
with the legal issue only.
Yes.
So let that be over.
Your lordship, we may be allowed to go on sale by recognizing their against the.
So those leads to more complications. Both sides are dissatisfied.
So
Everything will be subject to again orders of the court.
Your lordship, I have also in one division bench judgment we have get this order. So thereafter we have successfully sold one case to. Your lordship,
No, but
maybe come up after.
you see, if both of you are agreeable to have the auction sale done,
Yes.
why this should be kept pending here?
Only because of their news, your lordship.
Hmm?
Only because of the ATPFO news, your lordship.
No, but that has to be settled. You see, what is the fun in having a sale done when the sale is subject to again the orders of the court?
Your lordship, just 2 weeks maybe we'll take the complete instructions and complete.
You don't find anything to, because you are wanting an order, a positive order from the court to go ahead with the sale.
They are challenging the position of receipt. That is their challenge.
We understand that. But how can two things run concurrently? He is the receiver, you are the seller. Third party interest will be created. They will say that please give us possession.
No, your lordship, the third party will have to pay their dues also. That is as per rule line 7 of the perspective.
Now, why don't you, both of you to sit together, have an agreement done and close the matter?
We had the meeting. The thing is, they have recognized our due, but they feel they're going to give a final try. If not, then you will be before your lordship.
We will dispose it.
This is your item. Just wait for some time. Let us have the mentions first and then we'll take up the order.
My lord, item number 20, my lord. My lord, I pray for some time, my lord. In item number 20,
20.
after 2 weeks, my lord.
20 is 2019 matter.
My lord, in fact, my lord, yesterday I could not locate the file. I have to reconstitute it with my lord. I'm sorry, my lord.
Item 20. Just wait for a moment. We'll have the records. Yes, next.
Item number 46, exhibition.
46.
Who also recognize the agency on the last written source.
Yes, you want an adjournment. Upgrading. Just, we'll try to. Look.
Person from the other side, item number 6.
Item number
6. per direction of your number four, that is 29, 7, 56. So if you file for affidavit, one we have filed, and today one is going to file. now.
Okay.
Time for the
Both sides are
petitioner.
represented. Harbi Baran and the government advocate. Submit that one affidavit has been filed by the state in the matter, and another affidavit is being filed in course of the day. So accordingly, matter stands adjourned today, list on. Next Wednesday. List on. To 9/20/20.
Lordship, 8 and 9 are senior some difficulty, Lordship. Can we any other date, Lordship, except 8 and 9, Lordship?
8 and 9, no, we are fixing it on second. That is a hearing day. We reserve it for those hearings.
Second also, Lordship, is some difficulty, Lordship. Second, Lordship.
7 September.
10, September. If you, like.
Yes.
May I please lordship, by document item number 7 lordship. Lordship to the engagement which alarm is out of session lordship. Lordship matter may be listed after 2 weeks lordship.
At 2.
After 2 weeks.
After 2 weeks, okay. Both sides are represented on the prayer made by non-counsel for the petitioner. The matter stands adjourned today. List on. Yes, next, give a date.
Published.
May it please your lordship, item number 37 of daily list. As engaging counsel could not prepare the case, so matter may be adjourned for 4 weeks.
57.
Yes.
Okay, both sides are represented on the prayer made by non-counsel for the petitioner. The matter stands adjourned today. List after 4 weeks.
Yes.
List after 4 weeks. As prayed for.
Appraisal lordship. Application of item number 44. lordship. Many occasion it was not, it was just left covered. lordship. 44. lordship.
We don't know whether we can take it up. 44 can be upgraded.
Lordship.
We'll have to wait for some time. We can't assure.
Obliged.
May I please, your Lordship? Lordship, with the consent of the other side, I beg to mention item number 15, Lordship. Lordship conducting.
1-5.
Yes, Lordship, 1-5. Lordship conducting counsel, Mr. A.R. Shah has some difficulty today, Lordship. Only adjourned for the day, Lordship.
Please renew the prayer when the matter is called. This is 2019 matter.
Yes, Lordship.
Till 2021, we have some difficulties in adjourning at the motion stage.
Lordship, in this case, Mr. B. Pusilal is there,
We
Lordship.
have
He
to
has
make our
accepted.
renew the prayer when the matter is called. Unless we look at the record, we are not adjourning any matter up to 2021.
Yes,
Please renew the prayer when the matter is called.
yes, Lordship. Obliged.
Item 20.
And I'm sorry, my lord, hey, yesterday I could not locate the file.
What is that? Because this is 2019 matter. We have in motion column and admission column 515 cases.
My lord, I'm sorry, my lord.
2019. No, it's okay. We're not on that, but unless you look at the record,
Today is the 3rd day of list.
no, it's not that. You're not on 3rd or 30 days, but unless we look at the records, because at times the records are incomplete. Unnecessary, there's further delay. Okay, this can be adjourned. Both sides are represented on the prayer made by legal counsel for the petitioner. The matter stands adjourned today. List on, due date after 2 weeks.
40. Obliged.
It's not about the number of adjournments. The question is that unless the
Normally,
records.
my lord, I also do not pray for adjournment. Yesterday I tried hard to find the file, but
It's okay.
after 2000.
That. Unless we look at the record, we are finding it very difficult to adjourn.
Obliged.
Item 5.
It's page number 56, your lordship.
You see, whatever you do, you can go ahead, but not with the order of the court. In your writ petition, the prayer is not to allow you to sell the property. The writ petition is only to challenge their expression of interest.
Yes, your lordship. As in their
And
act, there
you
is
see
no
the anomalous
provision.
situation you have created.
Uh.
In this case, we have passed an order that 2, 3, and 4 may go ahead and they may not appoint. Now, you have taken only symbolic possession. You don't have the physical possession. You don't allow them to have the possession of the property. Now, please tell me
No,
who
you-
gives us an undertaking that if the property value diminishes because of some theft or something, some loss, who will compensate?
No, your lordship, just to clarify one point, the tea estate is being run by their persons only. That is in their.
Who will run it?
Yes. it
Without
is-
being an appointment of a receiver, if they are doing it, it is outside their scope of mandate.
No, your lordship, the tea estate is only in symbolic position with the bank.
Therefore, you see, this writ petition is in whose interest? It is not in your interest because you are not in possession.
Yes.
You have stayed the sale of the tea estate. They have a lot of dues to be recovered.
Yes. Yes.
You don't allow them to have a receiver appointed. Now, who is the custodian of that property? It is the borrower.
It is being run, your lordship. I have.
Who is running it?
So first of all, the dues, our dues are statutory dues. There is a secured capital. We are higher than, statutory dues are higher than the
You
secured.
see,
capital. Now,
that
what
amount
has
of.
happened- What has happened was, when we started this process, and this honorable court was pleased to.
No, I have a very simple question. Please don't give that much of answer.
Yes.
Who is in possession of that property right now? Today on date,
The possession, we are not in possession, neither the bank. Now the workers
Then-
amongst themselves, they are plucking the tea leaves and they are selling and running the garden in ad hoc basis.
then
We have not appointed receiver.
this difference is not in their interest.
And ultimately what has happened, my lord, the garden is going to be a sick garden in a while.
Obviously. So you are filing this writ petition for collateral interest. Who benefits out of this order of ours? We put your officer, the chief manager of this bank to take responsibility. Or you withdraw this writ petition. You have a meeting between you to settle the matter, or we put this bank.
To make clear, a meeting was held and we have given our dues to them. They have recognized our dues. It's not that they have not recognized our dues, they have recognized our dues, but they unfortunately, they failed in the auction. What, again, my learned friend has the instructions that they will also again try to reconcile and to go for a third and a final.
That is not the writ petition mandate.
I understand.
And your lordship, we will have very shortly a meeting with the ATPFO
No, better
regarding
wait,
the management
because
of the Bagan also.
We will saddle your officer with personal liability in this writ petition. If there is any loss to the garden, your managers will be personally responsible. They pay from their own salary.
Will your lordship just give me a short period, your lordship, so that we can complete the instructions on this issue.
Both sides are represented. The learned counsel for the petitioner pays for adjournment. Next para. On a query of the court, comma, the learned counsel for the petitioner has submitted that the concerned tea garden is not under the physical possession, but only symbolic possession of the tea garden was taken. Stop. Similarly, comma, Mr. M. Sharma, sorry, Mr. Big OS, no, sorry, Mr. J. Bora. Mr. J. Bora, learned counsel for the respondent numbers 2, 3, and 4 have submitted that the said respondents had wanted to appoint a receiver of the tea garden under the name and style of Ratanpur Tea Estate and Sapoi, SAPOI. These are both
Suppose
different. Okay, Ratanpur Tea Estate. Mr. However, in view of the interim order that was passed on 12/3/2026, comma, the appointment of receiver could not be materialized. Mr. V has further submitted that presently the tea garden is being operated by the workers amongst themselves. So accordingly, he submits that the apprehension of the respondent numbers 2, 3, and 4 is that with no management, the garden is likely to become sick and defunct, which would be contrary to their interest. Next para. Next para, in view of the submissions made at the bar, comma, as the court finds that the writ petition does not serve the interest of either the petitioner or the respondent numbers 2 and 3 and 4, comma, unless the authorities of the Canara Bank, comma, the petitioner, as well as the authorities of the Assam Tea Employees Provident Fund Organization, comma, arrive at a negotiated arrangement to protect their financial interest. Comma, the resultant loss to both sides would only be because of the pendency of this writ petition. Next para, accordingly, the learned counsel for the petitioner as well as the learned counsel for respondent numbers 2, 3, and 4 are directed to send a downloaded copy of this order to the petitioner and the respondent numbers 2, 3, and 4 respectively, so that they can arrive at an early decision to stop. It is made clear that if no settlement is arrived at by the next date of listing, comma, the matter would not be adjourned on the next date and the matter would be taken up for final disposal.
Yes, sir.
Next para. List on, give a date after two weeks.
Hello.
Or motion, item 1.
May I please, Your Lordship? The petitioner has been declared as foreigners by the order dated 14/2018 Your Lordship, kindly turn up at page 50 for the impen order. The learned trial court discarded the citizenship certificate produced by the petitioner due to linkage. Due to no linkage with the petitioners. Lordship, the petitioner has exhibited annexure that is 4A, PAN card, that is page 24. Where her father's name is reflected.
Which does not take cognizance of a post-reference document. You must have some connection with your father from any official document. You see, only yesterday, a very young girl came to my house. She's a relative of mine. She found out some stick. She thinks that that's a hammer, and she puts on the bangs my table and breaks the glass because she's acting as a judge. She wanted to say order, order. Just like in the movies, she took a hammer, broke my table. But by doing that, she does not become a judge. That's the same issue. Once you declare somebody as your father, there must be some connection. A PAN card is not a good, EPIC is not a very good evidence.
Even in her marriage certificate also reflected her parents' name.
Where is that?
Page 25. That is issued by the Gao Panchayat. Annexure 3.
This person was not examined. Gauhati, whether he was examined as witness.
No. No, sir. She got married in the year 1985. So that's why like she could not touch the boat along with her father. And she could not go to the school also due to poverty. That's only the PAN card is a documents to prove her.
She's not an
lit-
income tax payee. You see, the difficulty in accepting this certificate
Yes, Lordship.
is You see, the problem is with this certificate and acceptance of that is the Assam Panchayat Act 1994. The Panchayat was established only after the act came into force after 1994. So they would have no record of a marriage in 1985.
Yes, sir. Even that time, since she belongs to the village, so
We
no,
understand
she could not.
that is a personal knowledge.
Yes.
This man was not examined. Personal knowledge cannot be certified as a certificate of the Panchayat. Panchayat must have signed some record. And that record would not exist because this act came into force in 1994. The notification of that is
So this case, Lordship, she is also entitled to get the car, Lordship, allowed to apply for the car.
5th May
So there is
1994.
no other
That you can
alternative.
go ahead without the order of the court because the order, this order cannot be given because of the directions contained in the case of 6A. There it says it will not, the negative it is answered. So the government entertains your application, you can go ahead, but not on the basis of the order of the court. How would you overcome page 49?
There is a cross-examination. It is, page 48 is a type copy.
It's okay, we have a bit of reading this. You can read from 48.
Okay. Lordship, I born
How
at
do you
Hatir.
overcome this?
Born at Hatirgul under Pathar Gandhi PS. I have no documents of schooling. Only proof of age is a PAN card exhibit 1C. I have not submitted any documents of existence of my parents in India between 1966 to 1971. Exhibit 1 is not a false document answered in its suggestion. I have not submitted any documents in favor except the voter list of 1997 of Satyajit Chandra Das. I am not casting votes in MP MLA election till date. It is not a fact that I am a foreigner. Due to devoter, she could not cast a vote.
But then you have no documents. It's an admitted fact. You'll have to dismiss this matter. Because even in your written statement, you have said nothing. You not even said where your father was residing. You not disclose the name of your mother in the year of your birth. Yes, Mr. Sharma.
Cannot go beyond feelings, Lord Sudan. And Lord, say,
He has a very good document, but could not link.
yes, yes, Lord. Only connected document.
But this, but this opinion would be set aside in respect of her children, 4 children. Nilima Das, Gauranga Das, because there was no, they will not draw their lineage from the mother. They will draw from their father.
Lord,
That inquiry was never done.
yes.
Page 52. So this repetition would be partly allowed. There was no inquiry against them.
Yes. Yes.
But
Should, remand back the matter.
no, you can't do that. But J. Paul and the counsel for the petitioners. Sorry, petitioner. So here also your children did not join you in the writ petition.
Yes.
Without them being a party, we cannot even set aside that part of the opinion.
Is your- is your part of the-
बिचारा लगे तो उससे बात कर तो बाबा बोलते तो बिचारा नहीं वो सब मेरे बाहर था कि
These are few fundamental things. If the sons are declared, daughters are declared to be foreigners, they would have to be here to challenge it. At the time of the filing of the writ petition, as per your documents, one boy is major. You don't defeat them.
I
without-
asked them, but I asked them to file, but they will not agree because they are deciding outside the state. That's why.
By Ms. Jeva is also for the respondents, Explainer. By filing this writ petition under Article 226 of the Constitution of India, the petitioners, the petitioner has assailed the opinion dated the page 50, passed by so and so, in so and so, thereby declaring the petitioner and 4 children, namely number 1, Nilima Das, number 2, Gorango Das, number 3, Anjan Das, number 4, Anjana Das, at 5, Amarendra Das to be foreigners of post 25 to 1971 stream. Next, appearance of the petitioner, she had contested the proceedings by filing a written statement. And in support of the written statement, the petitioner had filed her evidence on affidavit, stating that her father is Santosh Chandra Das, SANTUSH, Chandra Das, who possessed a citizenship certificate as a citizen of India under the provisions of Section 5 within bracket 1, bracket close small a of the Citizenship Act for 1955, bearing number 833, dated 25/11/1956, issued by the Sub-Divisional Officer, Karimganj. The said certificate was exhibited as Exhibit 1. The petitioner also relied on a family identity card of village Ratanpur, RATANPUR, of Madhura, MADHURA, Madhura Gaon Panchayat, under PS Dharbon, UDHARBOND, issued by the Inspector of Food, Civil Supplies and Consumer Affairs, Kashar, which was marked as Exhibit 2. birth in India and the marriage to marriage with Pranay Das, Pranoy Das. The petitioner dies on a certificate issued by the secretary Jurbari, Jurbari, next word Defalala, Defalala, Gaon Panchayat, Karimganj, within bracket now, Sribhumi. Which was marked as exhibit 3. We feel very sorry for the quality of lawyers who are dealing with foreigners matters. Really sad. People who do not know how to draft, how to
Yes,
write,
yes.
how to articulate a petition, they start taking up cases. See, Mr. Sharma, the drafting,
Yes, Lordship, Ws as well as the evidence.
one of the horrible drafts we have seen. Para 7, I have 4 children, page 43. I have 4 children, doesn't give the names, only one Gauranga Das. Now, para 8, my another son Amarendra Das. So that means she has 5 children, not 4. Even does not know how to write. But out of the 4 children, the 5 children she has referred to the birth certificate of 2 children, namely Gauranga Das, within bracket exhibit, which was marked as exhibit 4, and the birth certificate of Amarendra Das, whose birth certificate was marked as exhibit 5. Though it was stated that she has a brother, Satyajit Chandra Das, Satyajit Chandra CH, Pushpa Das, who cast his vote in the year 1997, but no document regarding the brother was exhibited. In her cross-examination, the petitioner had stated that she was born at Hatirgul, Hatirgul, under Patharkandi police station. She has no document of schooling and As age proof, she has only income tax PAN card. Was marked as exhibit 1 within bracket small c. So she has admitted that she had not submitted any document of existence of her parents in India in between 1971. She denied that exhibit 1 was a false document. She has admitted that she has not submitted any document in her favor except the voter list of 1977 of her brother Satyajit Chandra Das. She has stated that she had not cast any vote in the elections for MP or MLA till date. So however, she denied that she is a foreigner. Next one. Stop. It appears from the record as well as the impugn opinion that in this case, the electoral registration officer for 12 Dharband UDHR BUND LEC having doubt regarding the citizenship of the petitioner, directed the LVO to submit a report. And on the basis of the inquiry report of the local verification officer, the report of the LVO was forwarded to the Superintendent Police within Kachar Constitution, would forwarded the same to the Superintendent Police Kachar Constitution, who had submitted the same before the learned tribunal, the Furnace Tribunal. To start. The learned tribunal rejected the evidence in form of the PAN card within bracket exhibit 4 within bracket small a. Even the tribunal is a match. The tribunal is an equal match to the lawyer who has drafted it, or he would be better. This tribunal would be better than the lawyer. Very sad. This is exhibit, PAN card. What is the exhibit number?
1/1.
1/1. Come to page 51. In the opinion, no, not that. The writ petition. In the opinion, he writes the exhibit as 4/8. Absolute incompetence. Absolute incompetence. Now what to do? Your argument all throughout is that the court should not appreciate evidence. Now for this, should we send it back?
Here, another PAN card is here. 4A.
Two PAN cards. Same PAN card twice exhibited.
It's part of the two PAN card. No, same. Same PAN card, not keep exhibited twice.
Huh? That's.
It was not exhibited actually. The one is not exhibited also. Exhibit 1 is the registration certificate also. And
So
4A.
there is something wrong here. This 1/1 is case number FT3rd D 191 of 16.
Not 4.
What is that? Why does this document come here? Whether you don't exhibit any document. The exhibit 6 is the standard copy of the voter list of this particular of the petitioner indicated by the. It's the learned tribunal. With reference to the PAN card within bracket exhibit 4 within bracket small a. Observe that though it shows the name of the father of the petitioner is Santosh Chandra Das. And the petitioner's date of birth, but it was held that the said exhibit was not proved or corroborated with any document linking the petitioner with the father. In this regard, it was further stated that the petitioner had never stated about a place of birth and no proof of date of birth was provided in the pleadings of the evidence. So it was held that the pleadings and exhibited documents regarding her father is also not corroborated with any other statement or document. Accordingly, it was held that the petitioner had failed to substantiate that Santosh Chandra Das was her father. The learned tribunal also observed that the projected father of the petitioner was 33 years in Exhibit 1 when he migrated into India within bracket Assam. But there is no pleading about the mother of the petitioner. The learned tribunal also found discrepancy in the age of the petitioner, who has, for her affidavit, had sworn her age to be 53 years, for which she would be born in the year 1965. But according to Exhibit 4 within bracket small a, she was born in the year 1963. It was held that the petitioner has failed to prove regarding her mother, their residence and existence of parents into India. So the certificate of registration in the year 1936. The learned tribunal also observed that to obtain a certificate of registration, a petitioner a person must show his or her existence in Indian soil not less than 7 years prior to the application. But in this case, the petitioner was silent regarding as to when her father had come into India and with whom. According as for the children were born after 1992. The court doubted the provisional certificates which were collected in the year 2000 and 2001. Accordingly, the reference was answered in the motive by holding that the exhibit 1 was not a trustworthy document, and the other exhibited documents did not establish that the petitioner is a citizen of India. Accordingly, the learned tribunal declared the petitioner as well as five children, namely Amarendra Das, Gauranga Das, Anjan Das, Anjana Das, and Amarendra Das to be found. Post 25 January civil scheme. Next one. At the outset, the learned outset of the petition was put to notice that as he was that as she was reciting the Indian opinion in respect of the five children of the petitioner, but none of the five children have been imprinted as a petitioner. And at the time of filing of the petition, the elder son of the petitioner, namely Amarendra Das, was an adult. And the dependency of this petition from the other son, namely Gauranga Das, immediately of India. As was the grand council for the petitioner was supposed to witness as to how without including the affected process as petitioners from the imperial opinion would be certified in respect of the petitioner was to take notice to that. The inquiry was conducted against them by the border police. Response from the council of the petitioner saying that the said specifically from the petitioners did not desire imprinting of the five children of the petitioner. In respect of the certificate of registration of Sri Santosh Chandra Das as a citizen of India under the provisions of section 5 within bracket 1 within bracket small a of the D of the Citizenship Act of 1955. But except for the PAN card, there is no linkage of the petitioner with the registered father. Petitioner projects that she has a brother namely Satyajit Chandra Das. In respect of whom the electoral role of the certified copy of extract from the electoral roll of 1977. Bearing application number 1177 only CA-2 issued on 7/9/2016. But project together of the petitioner did not come forward to prove his electoral role or regarding the certificate of registration of projected part of the petition. Is well settled that the PAN card is not a proof of citizenship unless the same are entered on the basis of the declaration made by the person applying. And that the PAN card to be proved by calling the acquisition made before the income tax authorities. In this regard, one may refer to the law laid down by this court in the case of Nadia RADI by HATUN versus Union Region. WBC 4986 of 2016. Decided on get the bill. From a very this court held that PAN card is not a proof of citizenship. And moreover, the petitioner was not a income tax payee, and that the PAN card was not proved by calling for the income tax officials regarding the application for PAN. Moreover, it was held that the PAN card contains the date of birth, and if the petitioner knew her date of birth, she substituted the same in the request statement or in her evidence. Which was not done so in this case. Because as per the finding of the learned tribunal, as per the affidavit sworn by the petitioner, her age was 53, and therefore she was born in the year 1965. But her age is 90, her year of birth is 1963 as per Exhibit 4 with the small a, for which no expression was tendered. The learned tribunal, on the basis of matters available on court, arrived at a finding that this was a case of D, invert commas, D, next word, voter case. And then prior to that the name of the petitioner was not entered in any document since birth, i.e. between 1963 to 1997. Resultantly, exhibit I have not been found trustworthy, the petitioner is declared to be a foreigner post 25 to 1971. Next slide. The learned counsel for the petitioner heavily relies on the certificate of registration within bracket exhibit 1. As a proof that the petitioner was a daughter of the of Santosh Chandra Das, in whose name he said certificate of registration was issued on 23rd of 1946. As well as he heavily relies on the Panchayat certificate within bracket exhibit 3. Accordingly, the learned counsel for the petitioner pays for remand of the matter. Next one, the specific query of the court of the learned counsel for the petitioner submit that her children do not intend to impede themselves in the petition. For which he has specific instructions. Next part. In this case, the petitioner relies on exhibit 1 for which is the certificate of registration, but is except for the PAN card. There is no document which links the petitioner to a protected father. You can sit down. So, although the petitioner has produced PAN card in bracket exhibit 4 by A, in view of the law laid down in the case of so same is not reliable without calling for the original records of the application. Also, when the year of birth of the petitioner does not, as stated in the evidence on affidavit, or does not match with the one disclosing the PAN card. As far as the Gauhati certificate is concerned, in bracket exhibit 3, it was the Gauhati were constituted in the state of Assam only after the enactment of the Assam Gauhati Act from 1994. Therefore, the Gauhati is not likely to have any doctrines regarding birth of the petitioner, marriage of the petitioner on 17/3/1985. The court finds supports in the submission of the learned counsel for the border entry matters that the Gram Panchayat is unlikely to have any record of marriage is taken place on 17/3/1985. When the Panchayat itself was not in existence then. Will be stated that the enactment of the some grant will have some Panchayat Acts Act from 1994. The some Panchayat Ordinance from 1994 is repeat. So therefore, there was the Gram Panchayat constituted after the mandate of the Constitution within brackets 70-3rd amendment that was Act of 1992. The state government certificate is not found to have been in any way. Next one. On the evidence of the PAN card, as there is the Gram Panchayat certificate within bracket exhibit 6 being excluded from the petitioners failed to link himself with the positive order, namely consumption of the draft. In this respect, the certificate will exist will be like an exhibit form, but it will be issued. The projected brother of the petitioner, in respect of whom exhibit 6 was exhibited, has not come forward to prove the identity of his father. Next part for the because does not find it. And it isn't to interfere with the imperial opinion. Next part. Be that as it may, from the context of the travelers records and the reference made before the Superintendent of Police from a bench. So no, sorry, Kachar from a Silchar. From a court does not find any material that there was any inquiry conducted by the border police with regard to the 5 children of the petitioner, namely number 1, Gilima Das, number 2, Gorango Das, number 3, Anjan Das, number 4, Anjana Das, and 5, Amarendra Das. This will be at page 52. How about as the petitioner does not challenge the imperial opinion on behalf of our children. 5 children. Come on. The court does not find this to be a case for granting any relief in respect of the corresponding numbers. Sorry, the 5 children of the petitioner. Owing to lack of challenge of the set of opinion insofar as the private, insofar as the right children of the petitioner is concerned. Petitioner is concerned. This is a comma. It will be open to the set five children of the petitioner. To take a decision as to whether they would next part, therefore, comma. It will be this order shall not be a bar for the five very before named children of the petitioner to take an appropriate because so advised. The set five children of the petitioner. Comma, on the ground that the there was no inquiry conducted in respect of them. And moreover, comma, five children of the petitioner could not derive their respective lineage. The mother must that would be within the domain of the sort of but she would derive the same from paternal side. Next part. The nutrition fails and savings disposed. Consequences of the impure opinion that is also is shall follow. Next part. This is impact the travels records it expeditiously. Next very parties are left to bear no loss.
Lordship, one observation may be made that this judgment cannot be a bar to availing a benefit of
This order shall not be a bar for the petitioner to avail such constitutional such statutory remedy, comma, if any, comma, available to her.
Item 2 for motion.
Yes, your lordship. Lordships, in this case, lordship, the petitioner has documents, but unfortunately, the case was not conducted as required due to incompetency of the lawyer. That must be admitted, lordship, as in the earlier case also. So herein,
You would be submitting a defamatory statement. You forgot to use the word learned.
lordship. So herein, the impugn order starts from page 29, lordship. And the petitioner has been declared a foreigner post 1971 stream, and the grounds that has been signed for the opinion is paragraph 9. First of all, the learned member has taken into account that in the written statement, the petitioner failed to disclose the relevant information as regards
Brothers,
his,
sisters, nothing
yes,
is given.
yes, lordship, parents, his siblings, etc. And even his date of birth is also not mentioned. And hereafter, as regards the documents, lordship, the learned member has at paragraph 9 and 10 has discussed that the certified copies of the voter list of 1966 and 1970, as well as of 1997, has not been proved by examining the custodian of the original record. That finding is to be looked into, your lordship. And basically on these three grounds taken by the learned member, the petitioner has been declared a foreigner. Your lordship,
No, because of the fact that there is a judgment of this court,
lordship,
which says that the certified copies would have to be put to the. We came across a judgment which says that what is this will have to be put with the records.
the lordship, this is a matter of 2018 lordship, and at that time, one judgment was there passed by our Honorable Justice Mr. Jacinta Malla Bujarwal in Mujibur Mia lordship. In that case, this coordinate bench of this Honorable High Court, right, that the certified copies of the public documents are not required to be filled. There was a judgment. Thereafter, the London tribunals also did not taken into serious note of this matter, and the case proceeded in this manner. Subsequently, this order might have come lordship that this is a requirement. In 2018, as I remember, lordship, as your lordship can also remember, there was a judgment of Mujibur Mia, I think. However, lordship, as regards the documents, lordship, I would like to draw your lordship's attention to the document, lordship, as I have submitted. The documents, he has documents from 1966 onward of his parents' lordship, of his father, especially 1960, page 9 lordship of my writ petition. That is 1966 voter list, wherein his the name of his father is recorded as Jasuddin Sheikh, SK. Second, Safaddin Sheikh is his uncle, paternal uncle. Palani Bibi and Okhaya Bibi. Okhaya Bibi is the wife of Josuddin, that is written as Josumuddin. The name of the father of the petitioner has been written as Josu Sheikh, Josumuddin, and Josuddin also. That has been stated in the written statement. In the year 1970 also, Josuddin Sheikh, page 12 lordship. Jasuddin Sheikh.
Because the judgment which we have found it, that is, it says that certified copies are admissible as secondary evidence. That is Isiron Nessa versus Union of India. It was a 1940 GR 685.
Yes.
Be prepared with that. We'll take it up next week.
Lordship.
We note it down 2019
Yes, Lord.
GR 685.
Page number, lordship.
2019 GR 685.
Lordship.
In GLT, it is 2020, volume 3, GLT 531. Isiran Nessa, ISIRAN, Isiran Nessa, NESSA.
Next week, lordship. Next week, lordship.
Next week, you have to be prepared. We are giving you, we have to give you some time.
Lordship.
You said that there are judgments which says that certified copies can be accepted.
Lordship, there was
No, it's
one
okay.
yes, lordship.
You must be given an opportunity.
Lordship.
Both sides are represented. The learned counsel for the Press is granted time to address the court on the admissibility of the certified copy of the electoral rolls. exhibited certified copies of the orders do as admissible evidence. Matters is adjourned today. List on.
Next week, on 9 or 7, on 8, I have some difficulty. On 8 and 11, I have difficulty. I shall be out of station.
9/26.
Lost.
Item 3.
This is my very last order, my lord. Learned Premier was directed to produce the record of the petitioner's elder brother's case, my lord, which is 50-5962.
Thanks, Lordship. We will get record only if that elder brother Siddharth was declared as Indian, this is only available, Lordship, but entire record is not available, Lordship. They are still now they are searching, Lordship, if possible, Lordship. Yes, Lordship.
Mr. G. Sharma, standing counsel for the Water and Electric Matters, submits that the authorities could only locate the reference to the case number 5962/G/D/01, wherein the proceeding was declared to be not a foreigner. However, the authorities have not been able to get hold of the record. To locate or get hold of the record. Next, according to the matter stands adjourned today, list on give a date after 4 weeks. Next, the learned standing counsel for the Border and Electric Matters shall in the meantime, the records are located from the standing counsel for the Border and Electric Matters shall produce the same of the next date of listing. Next, the learned standing counsel for the Border and Electric Matters is permitted to send download the proposed order. The concerned authorities. Next, list on
28 September.
Foolish.
For motion, item 4.
Here also Lordship was directed to take instruction in respect of whether that person concerned was in detention camp or not, Lordship. He is not at present in detention camp, Lordship. He was released during the COVID period, Lordship. Released, Lordship. But not expelled till death, Lordship. He was released from the detention camp, but not expulsion was not done.
Okay. I think Ms. Verma was there. We wanted to send back this matter. Due to some reason, but I'm not remembering what.
No. Also, no.
None, the person called for the petitioner. All the respondents are represented. In this case, the in this case. As per the order dated 29/4/2019, the counsel for the petitioners had submitted that they were no longer representing the petitioner as the brief was taken back. And some time was sought for to produce the acknowledgement. Similar prayer was made when the matter was listed on 15/7/2019. As per order dated 23/10/2024, this court had observed that the record reveals that on 14/3/2019, the brief of the petition was taken away by one Wajid Ali, WAJID, Ali, one son of the petitioner. And that as per the records, the petitioner was then under detention. Next, on 26/8/2026 and 26/8/2026, petitioner remained unrepresented. It was made clear that if the petitioner remains absent on the administrative listing, adverse orders will follow. Next paragraph. The Mr. G. Sharma and Srinivasa for the border and active matters had submitted that as per instructions received by him, it was during the COVID period that the petitioner was released on bail pursuant to directions issued from time to time by the Supreme Court of India as well as by this court. Next part. Neither as it may, as the petitioner has remained unrepresented since 2019, this request is dismissed for non-prosecution. Next part. Let me what is it? We shall send back the records received from the concerned tribunal along with a copy of the order. We made a part of record by the said learned tribunal.
Item 8.
And new motion related to the contested case, my lord. The impugned order is case period 101. My lord, 5 persons have been examined, my lord, including the father of the petitioner. The father of the petitioner has been examined as DW2, my lord.
Okay. But this is now the counsel for the petitioner. Counsel for the respondents. Opinion is at page 101. Dated 24/2/2026. Reference case is in first paragraph. FT case number 735. The petitioner declared to be a foreigner of post 25/1971. Notice returnable in 4 weeks. Extra copies will be produced. Copy the records. The prayer for bail is opposed by the learned standing counsel for the FT border and exim police. Next paragraph. Bail of rupees 5,000 to the satisfaction of Superintendent of Police Border, Borpeta. Please start the phones.
Objection.
Item 9,
May it please the lordship. Lordship is a contested matter from, in opinion dated is 6/11/2025, which is at page 46, lordship.
47. Mr. S.K. Chakwan and counsel.
A.K. Hajam.
A.K. Sorry, Mr. A.K. Hajam and counsel for the petitioner. And so for the respondents. Same order here. Bail of rupees 5,000 to the satisfaction of Superintendent of Police Border, Borpeta.
Borpeta.
Page 46 is the opinion dated 6/11/2025. As by Sunswing case, reference. In petition to be a foreigner post 25 in 1971. Still, bail is 5,000.
Deeply honored. Nearly lordship. Contested matter lordships. Page 81 is the my lord impin opinion lordships. There were two reference to your
There are also say. Heard Mr.
M. Hock.
M. Hock, learned counsel for the petitioner and so and so for the respondents. Opinion is at page 81,
Lords.
dated 31/7/2025, passed by so and so. There is two references have indicated in passage number 1 and 2. By which the petitioner was declared to be a foreigner post 25 to 1971 stream. Notice, extra copies, notice returned in 4 weeks, extra copies, call for the records. Bail to the satisfaction of Superintendent of Police Border, Mangaldayi. Davam, Mangaldayi.
Yes, one.
Okay, please start the comments.
Page 26.
26.
Yes.
Because at D, it should be J. That's the sign and everything. $26.
Notice returnable in 4 weeks. Photos in 2 days, call for the records. Bail of rupees 5,000 to the satisfaction of Superintendent of Police Border.
DCP Kamrup.
Acha, DCP, okay, Deputy Commissioner of Police Border Kamrup, Electro Gauhati. List after 4 weeks on the same. Yes, Mr. Huda, we'll update your matter, which is your matter.
So we here to take your notices and then item number 16. It may come in the second half, but in the second half, I have some difficulties.
Okay, we'll take it up
This may be actually maybe posted after 2 weeks at least.
after 2 weeks, just a moment.
Okay. 16.
Okay, it has come for the first time.
No, sir.
Both says are represented. Pursuant to the order passed earlier, comma, the records of the tribunal is received, comma, which requires examination. Next, on the prayer made by Mr. Sudan and counsel for the petitioner, the matter stands adjourned today. List on the date after 2 weeks.
That's all right.
Always a pleasure hearing you.
That's it.
It's always a pleasure hearing you.
Not done. Good pickaxe. Well,
Item 12.
Yes, item 12. The ex parte opinion. of 23.
But now they are willing to contest the case.
Have to go back, page 36. 37. Down below is the report.
Yes, yes.
He is not found, therefore it was affixed in the notice board of the Gambura.
But there was a high court order, Lordship, page 45.
45.
Page 45. Why it was an instruction?
No, he is citing it for an example. That earlier also we did that.
Yes, look.
If the lawyer is not there, you find difficult to get him. John, we'll take it up some other day.
Yes, look.
The petitioner remains unrepresented on call. Gustav, however, all the respondents are represented. For ends of justice, the matter stands adjourned today. List in the motion column on 2/9/2026.
আৰু দুটা আছে।
Item 13.
Made please, Lordship. Opinion dated is 24/2/2026, which is at page 33. Lordship.
33. Take as well, the petitioner and so for the respondents. Opinion is at page 33, dated 24/6/2026. Passed by so and so in case number so and so, reference number so and so, by which the petitioner were declared to be a foreigner post 25/3/1973 Street. Notice returnable in 4 weeks. Call for the record. Extra copies in 2 days. Call for the record. Bail of rupees 5,000 to the satisfaction of Superintendent of Police Border,
Agreed.
Galvi. List after 4 weeks. Deeply applied.
Item 14 for motion.
2020 order, Lordship. 2020.
The petitioner remains unrepresented on call. However, all the respondents are represented. This is at page 61. Dated 24/7/2020, passed by so and so, in case number so and so, reference number so and so, by which the petitioner was declared to be a foreigner post 25 to 1971 stream. Next paragraph. In view of the inordinate delay in issuing the impugn opinion, keeping the issue of maintainability open on account of delay in latches, issue notice returnable on so and so, give a date after 4 weeks. Extra copies within 2 days, call for the records. Next paragraph, the prayer for bail shall be considered on receipt of the travelers records. Next paragraph, in the meantime, if the petitioner, namely Musammat Sobia Khatun alias Sabia Khatun, is apprehended, she shall not be deported out of the country without order of the court. Next paragraph, list on so and so. Give a date after 4 weeks.
If already not deported, lordship, that
Hmm?
line may be good. If already not deported, what happened, I don't know, lordship.
Okay. If already not deported, shall not be deported out of the country. Okay. We'll continue post lunch. Yes, Mr. Chaudhary. You are sitting as an Inspector General of the court.
No, my lord. I was just trying to learn the law, my lord.
With your lordship. Item 21, lordship is rising at 3:45. It may not reach, lordship. The petitioner is a coach Rajvanshi, and lordship, there is a notification which says withdrawal of cases against coach Rajvanshi, lordship. So. Is it something?
You tell them they have to take instructions.
Lordship, did it.
My lord, it is admitted position, there is a notification. I know that there, the notification is there. Only thing is that they ascertain whether he belongs to Coach Rajvanshi or not, that's not all. Because
I
this
have
is-
been informed that, lordship, all the Bormons in the Bongaigaon district are from coach Rajvanshi, lordship.
But they have to.
Lordship.
Because I have no personal knowledge, we both have
Yes,
Lordship.
yes,
no personal knowledge about this.
yes, but that is not all.
So I made a mention for listing of this matter, lordship. There are 7 to 8 matters of Burman communities, lordship, from Coach Rajvanshi. So if your lordship, it has been confirmed, then we can list this matter. Okay, so that is possible to be confirmed. 21.
I cannot list of them already.
No, one month, Coach Rajvanshi, I don't have to make a report. No, I will let us know link it. Hopefully, the Coach Rajvanshi will confirm.
You know, in a lighter note,
Lordship.
we know about two famous Burmans, R.D. Burman and S.D. Burman.
They both
They
are
have
from
not
Bengal,
got Coach
Bengali,
Rajvanshi.
lordship.
No, I don't know. You said that Burmans are Coach
Lordship, I have
Rajvanshi, so we
been
say that.
informed that from Bongaigaon, Wayapuri,
No,
the
that's okay,
Burmans,
but-
lordship,
They will have to say.
lordship.
I know only two Burmans.
There are some
Why?
matters, lordship, if lordship permits me, then I can pray for listing of these matters.
No, let them find out.
Yes.
Lordship,
Instruction. You give them a list, you will find it
Yes.
out.
lordship.
So that we can also verify whether they belongs to the or not.
Coach Rajvanshi.
If that is so, my lord, your lordship can close all those matters.
No, we don't know, we can't say that.
Yes,
Because it is for you to say. It says that any pending case shall be withdrawn. Now, in this case, there is an opinion.
Yes, madam.
Now, what is the stand of the government? You will have to find it out.
Item 21.
Only the opinion of the two government.
This is item number
21, Lordship. আমার আরো কোনো ইয়ে হলো? এই দিন বলুন। Lordship,
of your writ petition. You see, this is your admission. Here at page paragraph 5.
Lordship,
The name of the mother of Oki is Jugla Burman. The parents of the Oki entered into India in the year 1964 from East Pakistan. And since then they are residing under so and so. I am not questioning you, but I'm just saying that this is what the facts are.
Lordship,
So, let us see. But it would be better if you bring this on record by way of an affidavit, so it remains on record.
Lordship.
You bring this by way of an affidavit, because you must state.
My
You
learned
see-
friend is suggesting one
Not
thing,
that, not
Lordship.
that. You see, we
Lordship.
have reasons to say so. That is why when you put up this issue, I showed you this paragraph.
Lordship,
The reason is that if you claim that you are Kush Rajvanshi from that region, you have to make that statement somewhere.
Lordship,
Then this, to assist you, then this would come. Then they will have to take instructions.
Lordship,
Because right now, this is there. Page 36, that observation is there,
Lordship.
correct? What says the representative? The clear made by Mrs. R. Chaudhary, Bernard, Senior Counsel, assisted by Ms. S. Ahmed, Counsel for the Credit Court. The matter sent adjourned to enable her to file an additional affidavit in the matter.
Lordship.
Just after,
1 week, Lordship.
just after week.
Obliged.
We are returning you back this
Lordship.
notification, you can visit by way of an affidavit.
Happens to fund the-
Upgraded item 33.
That's the affidavit to six. Six. Respondent six or eight. Yes. Nine. Zero reply.
And you have the journal, the police records of the entries when they got the information. Hmm? Where is that?
Dana. Six. And then you get it. So six. 64 to 60. Baro record. Baro record.
नहीं
Whether SP has filed a ticket. Is. No, it is 55, not 56 it is. 5. 61. Okay. 61. No, copy. SP. Hey, SP for ability to control. No, ability to control. It will reply. No. Nothing. The GGNT of Julia case, madam. Mother, GGNT number 007. This is with regard to this petition. That is another. That is next one. GGNT 30 is of next item number 24. Here also, lordship 01 side of 9. The indication, sir. Nice. Nice.
60, page 60, no? In page 60, Lordship, they have, it is the same superintendent of police, he has stated 1, 2, 3, date of apprehension 35/2026. This is the communication he has made to the Deputy Inspector General, Border, on 3/6/2026. Six zero, Annex A. Extreme right hand column, date of apprehension. Serial number 3.
Around my daughter, I will leave that on the communication, the detention, they apprehension set is strongly difficult. But CTNT shows the detail, it was detailed.
And page 38 of the,
Right now, we are not forming an opinion, we are just hearing the matter.
No, no, my daughter, I'm just clarifying my opinion.
and page 38, Lordship, there is something. This
No,
is the-
60, you are showing a 60?
Yes, Lordship.
What is there?
60, serial number 3 in the chart.
Ah. This is
Extreme
30
right hand column, date of
34,
apprehension.
2026.
Yes. And page 38, another disturbing, Lordship, is there.
38.
This is extract of the order sheet, page 38. The translated copy is of page 37. Lordship will go through the vernacular, page 38.
Just
Last paragraph.
yes.
Page 38, last paragraph, Lordship. I'm married.
Yes.
দৰখাস্ত চোৱা হল, প্ৰাৰ্থনা মঞ্জুৰ কৰিব পৰা নাযায়। গোচৰত সন্মানীয় গুৱাহাটী উচ্চ ন্যায়ালয়ৰ ৰায় মৰ্মে পুনৰ নতুনকৈ সিদ্ধান্ত প্ৰদান কৰি হুকুম দিয়া হওক। This is the extract of the order sheet. This is dated 29/5/2026. And this goes to show that on 29/5/2006, no fresh opinion was rendered. Otherwise, normally language is this opinion in a separate sheet. That is the language adopted by the tribunal. Opinion is kept in separate sheets. Therefore, my submission would be at the time of detention, since Lordship is here in the writ petition, the order of the tribunal declaring her to be foreigner was set aside, Lordship. So at that point of time detention, there is no declaration as such that she is a foreigner. SOP to go, sir. SOP. I'm the next one. To be. To be. In the SOP, Lordship, there is a modality lays down, and that is this detention and deportation is also in violation of that SOP also. Because Clause 2, C1, Lordship. You see.
Yes,
May I read it?
yes.
Page Lordship, it is bottom, page 3. Huh? May I read it? C.
Yes.
Removal of declared foreign national. In case of declared foreign national, identified by the Foreigners Tribunal, the DC will pass the removal order as per section 2B of the Act of 1950 straight away. In such cases, no the detection process is necessary once they have already exhausted remedy available by approaching high courts, and in some cases the Supreme Court as well. In some other cases, such the foreigners might not have preferred any appeals, Lordship. Here is a case, Lordship, where even the opinion was not rendered at the time of her detention.
Yes.
These are the lordship basically.
Yes.
Somebody, our, it was about 150, 120 around. And my that is by the India police station, it was forwarded at the time of 14, 16, but it was over.
You please tell us if the opinion or copy of the opinion can be given to the police, why 5 days to give certified copies? No, that means, you see, there is some malice somewhere. We have malice in fact, malice in law.
I cannot say because I'm again on behalf of the ST on because criminal has been met personal for it. So I cannot.
No, that's okay. But as a, you see, you are the authority under whom they are working.
No, my lord, it's done, my lord. If they apply, probably the certificate can be given. There is no.
Look at the, you have the writ petition, see the certified copy. You see the date of application, date of copy, 5 days.
You think they apply for,
Yes.
it's ready for 4 6 months.
You see, what happens if, supposing my father gets lost from the court, what do? I'll apply for certified copy or I ask search my father. What would be the first thing I would do?
Certificate copy will be later on.
Certified copies will be later on. So on 2/6 the application is made. Certified copy is made ready and given when?
Maybe on 4 months.
Then why not same day or not immediately? No, the case of the petitioner is that on a particular day after this opinion on 4th or 5th, they went to the detention center, the mother was there. Next day, they go there to take signatures and the mother is lost.
That is my lord.
That means you are waiting till the, what you call the,
No, my lord.
there can be no other reason.
My lord, you not see the affidavit filed by the SP, my lord. That explains correctly.
6.
What happened, my lord, expulsion order was passed prior to that. Unless the opinion is there, the expulsion order cannot be passed by the DC prior to that. And only after receiving the expulsion order, my lord, it is admitted them also, expulsion order was passed. Your lordship has related expulsion order.
So the state machinery is working in tandem.
No, but that is.
Opinion is passed, person is arrested, deputy commissioner passed the expulsion order. No time given to get certified copies and the person is expelled. No, the country must have a rule of law. Did the deputy commissioner file an affidavit when how the expulsion order came to be passed? Are we having that affidavit? Yes.
Deputy Governor.
It's not a particular.
Mr. Sharma? Do you have anything? The expulsion order is on record? Mr. Datta, is the expulsion order on record?
District Commissioner is a party, Lordship, it is respondent number 7.
Is the expulsion order on record?
No. No. No, expulsion order it is not, it is related to the Deputy Inspector General of BSF. Expulsion order is not on record. No, it is a communication by the SP.
Mr. Datta, you can come this side. We are unable to hear you. Please come to this side. We are unable to hear you.
Next, let's see what. 71 of. Six or something. Mark, you are. Last one. No. No, that's okay, 60. 71. Right, didn't I? Page 71 अपना record of किया है. Page 71 record of the. हो गया है. अपना record 71 की. No, मूड करो. Page बड़ा ना स्कोर पे. ठीक. Page 71 let's say. Yeah, under section 2 is there. Affidavit filed by respondent number 6. Last page of it. It's an access. I'm able to see. Taken a page 1. Tingi puri सकता है. मुझे जगह कॉपी तो नहीं. More copy to. Yeah. Fully within the system. Okay, it's fully using an opponent. Yes, it is in record.
my activity. Second one, they will, the order was first. What they will send to Makiama. What is group of, then. Yes, 65, 65 is here. Yes, yes. Four, 6 months, 3 day work in Patla, 4, 6 days, until over this. Along the petitioner, another 3, to the minus 3 book. Well,
Three
we were
book is
supposed to be reported on an expense. And from there,
Zillion, right?
they were expense, but
बाकी के पास ये तो zillion है, श्रीभूमि zillion है something.
from the board, yeah.
श्रीभूमि zillion के नहीं, बाकी हिंगा सब. कोई शेड्यूल या श्रीभूमि zillion के.
Before, might not be in area of 29 itself, FIP was done in the Nova itself. That is a 49 information facility. That has been captured on 29 itself without our state. Formal is, the formal is, final formal is done. After the FIP, he has to be sent to the Mahaprabhu. My lord, page 64 onwards. Your lordship will find explanation with regard to 3, 4, my lord, page 65, my lord, middle part. After With regard to my lord, power of that SOP, my lord. The SOP. My lord, recently Government of India has notified the illegal Immigration and Foreigners Act 2025. And on the basis of that, my lord, the order, the Immigrants and Foreigners Order 2025 has been notified. And this is not only here, my lord, earlier also this provision is there. In that chapter 2, my lord, restriction on certain activities of foreigners. Why did, my lord, the movement of the foreigners is restricted? Absolutely, my lord. My lord, chapter 2, restriction on certain activities of foreigners. Rule 8, my lord. And on the basis of this only, my lord, the detention centers are renamed as holding centers, my lord.
But look at this.
Yes.
In chapter 2, where do you find the procedure which was adopted in this case is permitted?
No, my lord, that is, my lord, what the, first of all, my lord, once he has been declared foreigner, my submission, once he has been declared foreigner, in fact, my lord, if I may submit, my lord, there was no provision of bail earlier, even before the Honorable Court. Once he has been detained, my lord, he has to be remain in that situation until he is deported. Only after the Supreme Court judgment, my lord, 1045, where my lord said who has completed more than 2 years, but their deportation is, my lord, not taken place. They may be released because the deportation was not taken place. Otherwise, there was no provision of bail. There was no, once he has been detected, my lord, in another case, my lord, we have filed an
You should have
affidavit.
raised this argument from 2016 onwards. When this court says 2016, I am aware
Yes.
of the grant of bail.
No,
I never found this argument being ever made that this
no,
court
my
will not
lord,
grant bail.
that's why, my lord, the provision of bail was not there, but it is subsequently developed by the Honorable Court, my lord.
Under Article 226, the power is.
Yes, absolutely, my lord.
power
That is
absolute.
why, my lord. Otherwise, there was no provision of, because this absolutely, my lord, if your lordship may kindly see the civil authority or any authority of specific central government in this we have made by order in writing direct that any foreigner shall comply with such conditions specified therein. My lord,
Where is the direction? Show us. We are waiting for it. Where is the direction? You see, the number of defaults are many.
yes.
Number one, we gave notice to everyone to file an affidavit.
Yes.
Now, assuming that a man A is arrested from here and taken to Ladasel police station, what will the police do? The man is to be taken in the prison from here.
My lord,
And the jail, in the police station, Hajat, he is being kept. What is the first duty of the officer in charge of the person arresting? Inside the police station. What does your manual say? Your manual says that an inventory of the person must be made as to what are the things he is carrying. If he is wearing a watch, he is wearing a jewelry, if he's wearing something, he might have money in the purse. All will be documented, entered in the prison, in the thana, and then only he will be kept inside. Because it's not permitted to keep many things. So if the copy was granted by the tribunal on 29th and handed over to the police, that copy was never documented. We gave an opportunity, you don't produce that. Inference in the negative can always be drawn.
No, my lord, let's see, my lord, this is with regard to restriction on certain activities of foreigners. That is then, next para, my lord.
Where does it say that immediately after the opinion, he will be taken into custody without following due process of law? How do you take into custody? What authority?
Once the opinion is passed, he has been.
But then some entry must be made somewhere.
No, my lord, your lordship may kindly see the next para, next
At
page.
1:30, the person is taken to custody. Your affidavit says it is close to the police station.
Yes.
Entry is made in 16.02.
No, that is, my lord, generally, my lord,
No, we are
No,
not
no.
questioning your
Yes,
precision
yes.
of time.
No, no, my lord, what is that, my lord? Generally, in case of, my lord, I don't know, my lord, whether it is permissible or not, but generally, in case of, my lord, foreigners, no entry is made when it is detected. My lord, that is, but, my lord, well, my lord, if your lordship may kindly see next chapter, my lord. That is with relevant to prevention, detection and restrictions, movement and deportation of illegal migrants. Chapter 3, my lord. Chapter 4, my lord. Rule, this is order 12(4), my lord. That is, in case of illegal migrant apprehended within India, the following procedure shall be followed. This is the procedure. A suspected illegal migrant shall be imposed.
That is the first query of the court is only that a person has been detected to be a foreign national. That information came to the police how?
That is explained, my lord, that is in our affidavit itself.
You in your affidavit say that one constable so and so informed the
Local police.
the police station. Now that information must come on the basis of some order.
Yes,
Either he will be having the copy of that order, or it will be served to the person whom we are trying to arrest. Now, how this information percolates?
it is there in our affidavit, my lord.
It's not there. You only exonerate the presiding officer. You say that the constable so and so Saiful or something, he informed.
Yes.
I may miss out the name. Name I may forget. You excuse me for the name.
Yes,
This constable had informed, and accordingly the police came.
it is certainly, my lord, he has been detained in that, my lord, that.
No, but that is not what you say. You say that you see the language used is very,
Yes.
very precise. You say that she was, what you call, as if you did a search and you found out. Look at that affidavit. Which page is that?
That is letter on, sorry, my lord. Letter on, that is, that is letter point.
No.
Page
How did
64.
you arrest her?
Paragraph 6.
So page 6, my lord, para 6.
We'll tell you, it is at page 63.
Page 63, para 6, my lord.
Yes.
Yeah, with regard to para 11 and 12, the deponent denies the allegation made by the petitioner. The deponent begs to state it on 29th of 2026. AC Saiful Islam Chaudhary deployed at foreigners tribunal number so and so. Uriya Nagaon district had informed to the police station, border branch, that the honorable member of the foreigners tribunal were declared someone as foreign national. Depending his information, border police Uriya station.
You come to 64. This is something we have read. Please come to 64, first paragraph, fourth line. After
Yes.
collected the opinion copy order,
Yes,
border police came to know about this so and so.
yes,
That means the copy is collected.
copy is collected.
Where is that copy gone? You don't reflect it in the opinion. You see, you are taking a right of a citizen. You don't allow the citizen to come to court and file a writ petition. You say that you have a copy,
Yes, madam.
but this copy is reflected nowhere. Then come next. Border police came to know at so-and-so police Juria. Accordingly, police of Juria police station with the help of Juria police staff search for so-and-so and at about 1:30 apprehended DFN.
Yes, madam.
Now, please tell me, if A is in the court, I give him a punishment of, say, life imprisonment. Am I expecting this person to be here in the vicinity and then roam about instead of running away? And then you create a search. With that search, you apprehended him, trying to make it out that he is flying away. Now at 1:30, very close to the police station, you search and arrest him. What happens if you search for an ordinary criminal, apprehend him in the road at 1:30? Will it take you 3 hours to reach the police station?
No, no, madam. The police station is nearby, madam. It is not,
That's right.
madam, they send the, madam, the DFN to the, madam, SP office at 4 PM. That is the GPM.
But then please tell us, the copy was available.
Yes.
Why certified copy is not being given for 3 days?
That is, madam, that is not, because.
You are taking away the citizens' right to be in the country.
That should have been given. My submission also, if it applied, it should be given immediately, madam. That is always I submit, madam. It is not that, madam, the copy was not there.
No, this has happened because of the malice in law. The presiding officer became angry because the High Court remanded the matter. And he wanted to teach this procedure lesson.
That is not the, madam.
Has to be, there's no other way.
The presiding officer.
You
has
don't
filed a-
apprehend people who have been declared foreigners in 2016, 17, 18, 19, 20.
No,
And
madam,
this person you arrest, you take into custody only within an hour of the opinion. The copy of opinion is not being given to her. Family members go to the detention center. You don't give copy to them there also. Next day, when they go for the Wakalatnama and signature, the person is gone, vanished. You're looking at something which will involve all the might of the state to bring that person back from Bangladesh. The procedure will have to be subservient to the Article 21 and 22 right together. Life and liberty cannot be lost like that. This is not a due process of law. Everybody has a copy of the order. Police has a copy of the order. The district commissioner has a copy of the order. The superintendent of police has the copy of the order. The central government has the copy of the order. Only the person who doesn't have the copy is the declared for national whom we are sending back.
My lord, he applied for
Bangladesh.
certificate. Where I admit, my lord, he applied for the certificate copy. My lord, I don't know, my lord, why it was not served. But my lord, I could.
There are hundreds of reasons. The tribunal will now say that we did not have ink in the printer, could not print out.
That cannot be, my lord.
Why not? If in the High Court at times when we do our work, the printer is off. We have to spend 5 minutes time to get the new printer and then install it. The tribunal is not having funds. It will go to the, what you call, Home Ministry. Home Department will sanction 500 rupees and then the ink will come. So 5 days gone. You have an explanation, ready-made explanation.
That is not the explanation.
No, that this things can't happen.
That cannot be.
This thing
My
can't
lord.
happen. What the court, the magistrate of the court will be lost.
Taking her into custody immediately, then I think what you okay.
My lord, my lord, that can be your lordship. I also agreed that, my lord, if your lordship may direct, my lord, immediately on passing the figures, on the passing the opinion, my lord, that may be free copy may be served. Because that can be.
Maybe now if pass a judicial order, it has to be served.
Yes, my lord, that can
can't
be,
define
your lordship may
somebody
pass the
that
order.
that
I
liberty
accept
is
that
not-
also, my lord. Because that proposition I also accept, my lord. If it is served, my lord, then no question arises. Otherwise, my lord, everybody may allege this, that. My lord, if it is the free copy can be served on the same day, then my lord, the dispute will resolve, man. That can be done. That is your lordship, your lordship pass a judicial order, I accept it. No. Because the free copy, otherwise, my lord, what happens in this case is, my lord? Yes, my lord. No, my lord, what happened? Again, that issue, my lord. Yes, they have right to file a writ petition under 226 before petition on the court. But my lord, the legislature, my lord, my understanding, legislature does not give any authority, my lord, any provision of
The High
filing an
Court does
appeal.
not depend on the legislature.
Yes.
We derive our powers under Article
No,
226
that's,
of the
no,
Constitution of India.
what, I'm
We
not on
derive
that, my
our
lord.
powers under Article 21.
No, no,
We
my
are
lord.
not subservient to your laws.
No, I'm not
I'm
on
sorry.
that, my lord. My submission is your lordship may definitely pass an order. 226, your lordship, they, my lord, the provision of filing writ petition under 226 against the opinion. My lord. There is provision, that provision is well enough. But my lord, appeal, what my lord, my lord, lordship has said, your lordship has said, my lord, there is no provision of appeal.
Where is the provision for you to give copy to the police? Tell me the administrative order by which you are permitted to print the copy and give it to them.
My lord, because my lord, my submission is, my lord, because.
You see, if you have a law, it should be applicable to everyone.
Yes,
You can't make copies for the proceeding. You can't give copies to the police. You are not spending from your own pocket. You are using taxpayers' money.
my lord.
Where is
that
the account of the 10 pages you have printed and give it to the police?
Yes, my lord, there are, my lord, if your lordship may kindly take note, my lord, one thing, my lord, because the opinion is sought by the police, my lord, that to declare, to get an opinion. My lord, the police get it asked.
It's not the procedural law of the Foreigners Tribunal's order. The police is not entitled to a free copy.
There is some judicial pronouncement, my lord.
Sure.
It has to be served.
Sure, we were given
has to be
you
sent.
adequate opportunity.
Yes, I can produce, my lord. There are some orders where it is said, it has to be served, the information has to be given to the SPPD.
Information does not mean copy.
Yes. And secondly, my lord, because there is 6, my lord, opinion. It is just an opinion, my lord. The opinion I have to give back the opinion. Because it is the SP who seek opinion from the tribunal. And it is the duty of the, my lord, the order, my lord, tribunal to give back the opinion, my lord, if any opinion is passed. My humble submission is that. There may be some, my lord, here and there. I'm not saying everything may be correct, everything. There may some wrong occur. That's why I'm saying, my lord, if your lordship pass an order, that immediately on the passing of the opinion, it may be served to the, my lord, proceeding. Every case it. Yes, yes. No, there are cases, my lord. In another case, we have filed an affidavit. Today only, where there is on record, my lord, after declaration of to be foreigner, declaring to be foreigner, there were 1,16,000 persons are missing. They are untraced. So this aspect has also to it. And considering that only, my lord, prior to this, my lord, the Honorable Court has also directed the SP has to take, my lord, every consideration of all these things. He has to be, my lord, be responsible if the person is missing after declared to be foreigner. Yes, to be aware. Now, my lord, at this stage, I admit, my lord, there were no process. Earlier, my lord, prior to 2020, there was no such inactive, my lord, on the part of the SP concerns. But now, my lord, the authorities in this, in fact, my lord, this expulsion order only, there are 4 persons who has been expelled. In this, by this expulsion order, 4 persons has been expelled. This expulsion procedure is now taken place, my lord. It's rapidly.
No, for number one, we can understand opinion of 2018.
Those persons, my lord, very difficult to detect once they have been, my lord, met out of the detention center. 1,16,000 is not a, my lord. Yes, 1,16,000. It is. We have filed an affidavit Today it is listed, my lord, in item number 3526/2026. In that writ petition, we have filed an affidavit. We have brought into record, my lord. This is a huge number, my lord. 1,16,000 persons who have been declared to be foreigner residents. In item 46, my lord, we have filed.
You, what do you call, the authorities are slacking in it, they are not doing their work, you suspend few people. What
Now-
is the difficulty? You
now
suspend
they're
few people who have not been able to do their duty.
Whoever has been stressed out, my lord, now we are deporting, expelling.
You are competent to make a law. You make a law that High Court will not interfere, pass a constitutional amendment.
That is,
Under Article 226, the people who are detected to be foreigners don't have a right to approach the High Court.
that is, law is there, my lord, they can approach the honorable court by filing a petition. There is no bar on that, my lord. My lord, only in some cases, my lord, but we have fined. They does not approach the petitioner, they do not approach before the honorable court for
We'll
long. 5,
Fix the
6
matter
years.
for the order on Wednesday. But Mr. U. Dattar and counsel for the petitioner, Mr. A.K. Dattar and CGC for the Union of India, Mr. T. Sharma and senior government advocate, additional senior government advocate for the state, and Mr. J. Pang, and attorney counsel for the border and FT matters. Full stop. The submissions are concluded. List on 3/9/2026 for delivery of orders.
Permission then.
In second case, it is same thing.
Same, exactly. They are on detention, one of the apprehension is on permission. Not on 29.
That is, date of apprehension is 30.
1 day later, it
Yes.
is 30.
30.
We remember that.
I am a
Okay. Your name
S. Ahmed, madam. S. Ahmed, on behalf of Vichara Chaudhary.
in the next item, item 34. Same order.
Upgrade item 35.
May I please, your lordship.
My lord,
Yes, it and yes.
I received, there was comment yesterday only, and my lord, some mistake is there in petition. I have received one letter from deputy commissioner of Budai. We leave the party, deputy commissioner of Budai. Actually, this case under deputy commissioner. Jorhat.
Oh,
I may be allowed to amend the cost title, lordship. Respondent number 8 was wrongly
Your name?
demeduled. Demeduled.
Mr. D. Mehdi, learned counsel for the petitioner, submits that there has been an inadvertent error in arraying respondent number
8 lodge.
8. So it is submitted that instead of District Commissioner Hujai, Shankar Dev Nagar, it should have been the District Commissioner Jorhat. So accordingly, he prays for and is granted time to file an interlocutory application for amendment of the cost item. Next para, Mr. P. Sharma, an additional senior government advocate, has produced written instructions dated 25/8/2026 from the additional district magistrate, informing that the case of the petitioner does not pertain to or connected with the district administration, Hujai. Next para, be that as it may, on the prayer made by learned counsel for the petitioner, the matter stands adjourned today. List as and when the interlocutory application is filed.
Deeply honored.
You are there for whom? You are there in which matter? 35. Okay, record the presence of Mr. H. Is thus.
Obliged, Judge.
Upgrade item 41.
Or not, in this case, Lordship has,
Yes.
my lord, as per the last order, we have taken information in the bar council about the complaint lodged by the applicant, my lord. The bar council office has reported that since the bar council body is not functioning as presently, therefore notice could not be issued, the case is pending as filed. So we have to wait for, my lord, till the body my lord, body of the bar council is constituted.
Mr. Sharma, he is wanting for some additional time to take bail. You grant it then. He's come after 2 years, that is the 3 years. What is your age?
My lord, her is 45 years.
Heard Mr. A.R. Sigdar and counsel for the applicant, and also heard so and so for the respondents. Next para. By filing this interlocutory application, the applicant, who is the petitioner in WPC 943 of 2018, has sought for extension of time to take bail in terms of judgment and order dated 26/4/2023, passed by this court in WBC 943 of 2018. By the said order, where is that bail?
My lord, order dated page 13, my lord. Page 13, my lord, the operative person at page 15 remanded the matter, allowing page, my lord, 6, my lord, page 14.
Oh, this is not for bail.
Not for bail, my lord.
Okay.
We have a prayer for interim bail, my lord.
No, don't, it's not for bail. Extension of time to appear before the foreigners. Tribunal number 4, Nagaon at Juria. Submitted that by the said order.
This order court has
The-
demanded the matter to appear and examine the school teacher and his brothers. And this remand order, the petitioner could not follow, and the
It is
ultimately time has elapsed, my lord. The advocate
it is
concerned also
posited
not.
that it is posited that that by the said order, by paragraph 10 of the said order, the applicant was directed to appear before the foreigners tribunal number 2. Why one place it is 4 and another place it is 2?
My lord, it is 2, my lord.
No, somewhere we read 4.
My lord, please, 4, my lord, annexer 2. 4 is, my lord, annexer 2. But the petitioner case,
Is that 2?
2, my lord.
Okay. Not 4, it is 2. Nagaon. Julia is not there. Foreigners tribunal number 2, Nagaon. On 9/6/2023. Stop. In this case, it is projected that the council, the learned counsel whose name is reflected in paragraph Section 4 of this application, who was holding the brief for the applicant, did not inform the petitioner about the final outcome, and the copy of the order was also not provided. Accordingly, the applicant was not aware of the requirement to appear before the learned tribunal within 9/6/2023, the time allowed by this court. Next, the learned counsel for the petitioner has submitted, senior counsel for the learned counsel for the petitioner has submitted that in this application, it is projected, it has been stated that the applicant has made a complaint before the Bar Council of Assam, Nagaland, etc., against the said learned counsel. It is submitted that as per order dated 27/7/2026, the applicant had made an inquiry with the office of the Bar Council of Assam, Nagaland, etc., and the applicant was informed that as the Bar Council is being the Bar Council is not yet functional with the new elected body to take over, there is no development in the complaint already registered. Next paragraph. Next paragraph. The application is opposed by the learned standing council for the modern active matters in view of the inordinate delay. Next paragraph. In view of the projection that the applicant was not informed about the date of appearance. Taking a lenient view in the matter, the court is inclined to extend the period of time to appear, extend time for the applicant to appear before the learned member, Foreigners Tribunal number 2, Nagaon, within the outer time limit of 10/9/2026. Next paragraph. On the date of appearance, the applicant shall produce a certified copy of this order before the learned tribunal. Next paragraph, this order shall be read together with order, judgment and order dated 26/4/2023, passed by this court in WPC 943 of 2018. Application stands disposed of.
Deep love legislation.
Upgraded item 42.
Lordship, this is vacating as Lordship had given me liberty. So petitioner stands. On merit, we have stated Lordship, and apart from merit, Lordship, we had also raised that such types of matters generally heard by AFT, Lordship. That is our preliminary objection, but on merits also, we have dealt with the,
You shows from the act that it can be taken up by the AFT. On the proposed Tribunals Act, ensures that it can be taken up by that tribunal.
so section 3O, Lordship.
Yes, it will be covered by which part?
According to
It will be covered by which part of the,
3O, Lordship.
yes,
AFT. And also 14, 14 subclause 2.
You please read that part and show us which part you are relying on of this O.
So, 3O, Lordship, service matters. In relation to the person subject to the Army Act 1950, the Navy Act 1957, and the Air Force Act 1950, mean all matters relating to the condition of their service and shall include remuneration, including allowance, pension, and other retirement benefits, tenure, including commission, appointment, enrollment, probation, confirmation, seniority, training, promotion, reversion, premature retirement, superannuation, termination of service, and penal deductions. Summary disposal and trials where the punishment of dismissal is awarded, and any other matter whatsoever, but shall not include these matters, Lordship. And there after Lordship 14.7. 14.2. But we have not done it. Section 14.2, Lordship.
Yes.
Jurisdiction, powers, and authority of the tribunal, section 14.2. Subject to the other provision of this act, a person aggrieved by an order pertaining to any service matter may make an application to the tribunal in such form and accompanied by such documents or other evidence, and on payment of such fee as may be prescribed. So,
So you are saying that impropriety of the, if any, in the proceedings would also be covered by the
service matter. Lordship.
service matter.
Yes. Because the outcome will be regarding his service. The general court martial that has been stayed.
This is a plea we cannot accept. We have referred to the order of the Supreme Court in the 2022 SCC 714. That lays down very clearly. You have read that judgment, I suppose, when you are making this application. That judgment is very clearly stating the law laid down here is there is no power conferred on the tribunal to direct the matter to be remanded to a stage prior to the proceedings of the court martial. That is the law laid down by the Supreme Court that we have reflected in our order. In this application at page 33, you will find reference to that. And you see, even your concession, today if you record your concession of the armed forces, the Air Force, and say that they agree to this proposal, will that confer jurisdiction, which it does not have? Supreme Court says it does not have. Be prepared, we'll take it up, since it's a question of law, we'll take it up next week. Yes, yes.
On the, I'm just indicating that on the first day when your lordship, Prime Minister recorded that the court of enquiry, lordship, that part somehow they are not doing. The court of enquiry was ordered under the provision which says only a commanding officer can do it.
No, that's different.
My lord.
Their plea now
Yes.
in this application is that it was under what you call
It comes.
lack of,
meaning of.
no.
Sir,
It says lack of proper instructions that was done. Here somewhere it is there in the petition. I won't remember. I don't have a good memory. Here somewhere they say,
it comes within the meaning of service matter, so you have to go to the tribunal.
no, not only that,
Right.
but she says that the application here says
Yes,
that it was some lack of instructions.
yes.
Where I won't be able to find out immediately. Where is that? Lack of instructions, you have said?
That on the order, I have stated that,
No, in this application you have said. It is only because of that we are. Said here somewhere.
that in the order, lordship, orders only, I had,
No.
Court is saying that you have mentioned in your petition that there was.
lack of instruction is that in the order itself, because that was unlisted move now, that is why. Page 34, it is there, lordship, as this order has been passed without adequate instruction received by so and so, that is lordship's order. Because it was listed
No, here also you have said there that
in petition, I have stated that lordship, that
Yes.
is why lordship granted liberty to file a vacation application. That I have stated in my petition.
that is why the essential fact is whether the tribunal will have the jurisdiction or not.
Yes.
Supreme Court says it does not have. We are not entering the dispute right now.
That's only a preliminary objection, otherwise on merit
That's
also.
okay.
Lordship,
We are open to anything.
lordship.
You want to make the full instance hearing, we are ready to do it. You want to raise a preliminary objection, you sustain that.
Lordship.
So the Supreme Court says it can't revert back to the earlier stage. Tribunal does not have power. If the tribunal cannot turn its clock back, then the writ petition Supreme Court says will be maintainable. If that is there, then your application has no merit. If you want to argue by showing us some law, then we adjourn the matter. Or if you are ready to do the hearing, we complete the matter today.
Apart from that, lordship, on merit also, on the grounds on where,
In an IA, by filing an IA, you can't upgrade that hearing.
no, this is for vacation.
So therefore, the vacation is the only point is that
Lordship.
whether the tribunal will have jurisdiction.
No,
We send it back and the tribunal does not have jurisdiction, then what? It is within your power to give the time back? You can give everything, but you cannot give a time back.
so lordship, me fix it another that whether I will urge that point or not, on the next date, lordship. Otherwise, I will go on merit, lordship.
Merit will not have time today. take up the hearing. We are overshooting our time,
Lordship,
and time is limited.
yes,
3:45.
3:45.
Ms. B. Sharma, that CGC has referred to the provision of section 3O, read with section 14 within bracket 2 of the Armed Forces Tribunal Act, 2007, to urge that the dispute raised in the connected writ petition would be included within the definition of inverted commas, service matters, inverted comma close, and therefore the Armed Forces Tribunal would have the jurisdiction to adjudicate the dispute raised in the connected writ petition. Next paragraph. This court, in the order dated 21/7/2026, passed in the connected WPC 3787 of 2026, had referred to the decision of the Supreme Court of India in the case of Union of India and others versus XE capital small x full stop number. You will find it at page 33, para 11, number 3192684 W full stop SEP. I think it will be Sepoy. SEP full stop Virendra VIRENDRA Kumar, 2020 bracket close 2 SCC 714. Wherein, amongst others, the Supreme Court of India had expressed that there is no power conferred on the tribunal to direct the matter to be remanded to a stage prior to court-martial proceedings. Next paragraph. Mr. D. Mazumdar, Learned Senior Counsel for the petitioner, as respondent, has submitted that one of the plea taken in the connected writ petition is with regard to the maintainability of the proceedings on account of the fact that the, what is the term called? The
Commanding officer.
no,
The commanding officer.
the complaint.
Complaint. No, but the directing summary inquiry. Directing summary inquiry.
Okay, the order directing summary inquiry.
Assembly of inquiry.
Court of inquiry. Assembly. Assembly of inquiry.
Court of Inquiry, Assembly of Court of Inquiry.
Yeah.
Assembly of court of inquiry.
Assembly of the Court of Inquiry must be initiated by the commanding officer concerned.
And the person.
And it is projected that the person who had, the commanding officer who had initiated the same was not the commanding officer for the respondent. Next paragraph. Accordingly, the learned CGC pays for some time to address the court. Next paragraph, matters of job list again on. Can I have it on 8? I do have a motion there. Oh, 10th.
10th.
Okay, it goes to 10th of September. That will be a hearing day. And please inform the courtmaster day in hand with information to Mr. Mazumdar if you are going for a regular hearing. So then we have to accommodate our time,
Lordship.
correct? But inform Mr. Mazumdar in advance. And if you have to take up a 2026 matter for hearing, any case laws on which you are trying to respond, to rely on, both sides will give it us in advance. It is one day in advance. Otherwise,
File an affidavit. If they were going for final hearing on the matter, they have to file their affidavit.
Affidavit not yet.
why would you point it out? If there's no affidavit, you get a walkover. Doctrine of non-service is something I always, the tip of my tongue.
Can it be some other, can find out there are so many matters, division bench matters also there.
You agree with Ms. Sharma, we'll fix on that day. We have to rise because,
I'll just.
no, tell my courtmaster will accommodate because we can't wait. My sister has a wait.
For orders, item 1.
Wait, please, Your Lordship. Yes, madam. He's here. He also did file a small compilation today. Lordship, otherwise what I have consulted with my client here and what I have been told to do today is to withdraw this matter and go afresh before my lord, there is reasons for it, but also the judicial trend across the country has been going differently in this matter. And after. Yes, madam. I do not, madam. Yes, madam. In case of conviction, things are different.
File invoke section 5
Yes, they are also seeking condemnation of delay, madam.
in some matter.
Yes, madam, hot and cold at the same time. Hot and cold at the same time, madam.
That way, we have also,
In
they have-
in
they
the
have
state of
taken-
Jammu, they have gone for their own condemnation of delay against the order.
no, we are not on this. We are on the, of the Gauhati High
Yes, yes,
Court,
madam, got you.
where NI has filed application under section 5.
Because if it is condonable, then I also think.
And my lord, they, as a UOI, they should go for the legislative change and make this good for all as a recommendation.
No, it will be answered in an appropriate case, why it should be answered?
Lordship, I have also,
Otherwise, my lord, on
I have
August.
also prepared a note regarding summation of the.
This will come into use at some point of time.
Otherwise, my lord, in August 8th, the Supreme Court has delayed 3,157 days of delay when there was the same situation, but these acts were not also, I'm not pressing those. But the person was 22 years behind bars there also. State of Odisha, madam, my lord. On 8th of August, that judgment was passed.
This NI Act.
Not NI, my lord, but
What is
302 it
What
was.
is the language employed?
My lord, it comes from the same point which I am arguing that fundamental 21 should not.
No,
be-
no, no, what is the language employed? That is another kind of interpretation.
Yes, my lord, that is 302, where he was not granted, his appeal was not heard by Honorable Odisha High Court, stating that there is a delay of 22 years, and then that went to.
That's a different altogether. Here it's a statute, special statute.
Yes, my lord.
But Bombay High Court has said that shall should be read as me.
Yes, my lord. That
As
is also.
division
there.
bench.
Yes, yes. The judgment I have placed. And also, my lord, if reading down this point is being considered, then my lord,
No.
to that extent where it
No, that
it
actually
is harmony with the statute that Gujarat High
That will
Court
not be
is-
required if you're withdrawing. Why should we answer it?
Yes, my lord.
Lordship, in my note, Lordship, I have tried to cover all the points, even reading down provision also, Lordship.
We'll have a workshop on this and you will be the key speaker.
Lordship. Even Lordship, 1963 itself, Honorable Supreme Court says that regarding section 417, Lordship, there is a time limit is there, Lordship.
in the old 1989 CRPC, time limit is there within a period of 60 days, you have to prepare appeal against the acquittal lawsuit. Then Honorable Supreme Court says that these are special provisions within the CRPC. That's why it is mandatory. You cannot go beyond that. It's a 5 judges bench. I have also put the judgment also.
My lord, my only prayer is that in my withdrawal order, the court does not enter the merits, my lord, that may only be observed, my lord.
Bring the issue open. You decided in appropriate case.
My lord, only prayer.
Appellant who submits that he has received instructions to from the petitioner to withdraw this appeal without prejudice to the right of the petitioner to right of the accused to pay for bail. Next paragraph. Mr. R.K.D. Chaudhary, learned DSGI, for the respondents, as well as Mr. K. Govil, learned amicus curiae appointed in the matter, are present. Next paragraph, the learned amicus curiae has prepared a comparison of his note and case laws on which he intends to rely in form of a paper book. So, the effort of the learned amicus curiae in the matter to prepare his note and the paper book with case laws is appreciated. Most of these said comparison is made a part of record.
Have given some reasons which are for and against it are below compare.
Achha, where they said Mr. R.K.D. Chaudhary is present. Full stop. He has prepared a comparison of cases on the issue. So the same is made a part of the record. Then Mr. Bovai. Next paragraph. Accordingly, without prejudice to the right of the petitioner to the accused to pay for bail, this appeal stands dismissed on withdrawal. Yes. Application. Full stop. Consequently, the appeal stands dismissed.
The issues be addressed or answered in appropriate case.
Okay. Achha, then before that, dismissed, you will say that the issue raised in the connected unregistered appeal shall be in the reference. In the reference shall be answered in an appropriate case. Take a line from here. Keeping the issue open. The reference open to be decided in an appropriate case, comma. This is, it's the same language. Yes, Mr. Gogoi, what about your, we have recorded your appreciation, but what about your honorarium?
That part Maluna omitted. That part omitted Maluna.
You cannot omit, you have to treat all your friends.
Something has to, there has to be some transaction.
Okay. He'll give. He's been appreciated by the court.
I'll.
You did not record your appreciation.
I'll be lost, I'll.
Is this kahani mein twist? Perfect case. We came with the intention of deciding.
This is the option I had told him in the first.
No, in fact, on the first day,
Thursday I
my brother had also said that it's not, you're not precluded from filing a fresh.
Not sir.
But you had said that your client wants to insist.
Malab, at
Remember?
that period of time, my lord, she wanted to.
Then also in the concluding, I have the concluding point also I have discussed that part also, option I have discussed that part also.
Clients have become wiser.